his girlfriend determined he should not be driving to keep him from driving.
Consumed alcohol. I don't know where you've seen I consumed 16 beers. I'm with that number of beers and me not being a drinker.
In my opinion, you need to just basically give up alcohol. Versus Gabriel Faustin, case 25CR42867. Mr. Faustin is present with his attorney Ed Perry. The state is represented by Brian Goodyear. We are here for sentencing. Is there a statement from the victim in the case?
Your Honor, the victim is not present, and I don't have a, other than the PSI that would be in the, other than the victim statement in the PSI, I don't have any additional information, Your Honor,
Okay.
From the victim. But I would say we met with her and also spoke with her about the different plea options, and she was in agreement with this outcome, but I don't have anything in addition to what would be in the PSI.
Okay. Are they still together?
To my knowledge, no.
Okay.
They're not, Judge.
All right. Mr. Goodyear, anything on sentencing?
Yes, Your Honor. One open question I asked Mr. Perry, I'm not certain. And maybe Mr. Faustin can address this when he speaks to the court. Just about the license suspension he's going to receive for the OVI offense. I don't know that he was ever placed under an administrative license suspension. According to the report, it indicates that he had refused a breathalyzer, but then I don't see a 2255 form or any actual action taken on that. So I was just trying to determine the effective date of the suspension, which we can, I guess, deal with in a moment. But about the charge itself, Judge, he pled guilty to aggravated assault and to OVI, as you know. The aggravated assault comes from a strangulation charge. And my concern with someone like Mr. Faustin doing that, I mean, he's obviously very young. To my estimation, it appears to me he has an alcohol problem, because just in November of 24, he was convicted of reckless operation, which I'm assuming means he had a reduction, or he was driving very poorly.
It was a true reckless, Judge.
Okay.
It was not alcohol related.
But in any event, in this occasion, he was intoxicated to the point where his girlfriend determined he should not be driving. She took the keys from him to keep him from driving, and his response to that was to throw her on the ground, get on top of her, and strangle her, to the point where she could not speak and she could not breathe. The police came, found injuries, marks on her neck, which verified the story, as did, I believe, a couple witnesses. But I think it would send the wrong message to Mr. Faustin if he were not to be incarcerated for any period of time. He served 3 days on this so far, which will be the 3 days, I think, that would be necessary under the OVI conviction. However, and I certainly understand, Judge, he's a young man without any substantial criminal history. This is a felony of the 4th degree. I would understand the court not saying to prison, but from the state's perspective, he should serve a period of local incarceration, because I think the court needs to send a message to him that this type of behavior is not acceptable. We see people in court all the time that start down a path of abusing women, and that path does not end. And I think that regardless of whatever justification may exist in Mr. Faustin's mind for what he did, he made the decision to violently attack his girlfriend, someone that he was in a relationship with. And I think that it's important for this court to send a message to him that that is never acceptable. So the state would ask the court to impose a period of local incarceration in addition to any community control sentence that would be imposed. And again, I just need to figure out the effective date on the suspension in addition to that, Judge. Thank you.
All right, thank you.
Actually, I was looking through
Oh, did you?
Yeah.
I just presented Mr. Goodyear with the transcript from the lower court just to see if the ALS was in that stack of documents. I didn't have a chance to do it. Thank you. A little bit different. I think the message to this young man, a 19-year-old kid who by all accounts left high school after sophomore year, he got his GED and he began working immediately, and hard work paid off. He started his own landscaping company. He grew from some 10 lawns to 60 lawns over a period of 2 years, and by all accounts, financially he was doing very well for a 19-year-old, but he was no adult. He did not have any life experiences. This was the first and only relationship he had ever been in. And I would submit to you, Judge, this relationship was quite strained at the time all of this was happening. Carly was trying to leave him, and in response, Gabe wanted her to know that he could leave her, so he went to the fair. He did consume alcohol with his friends.
16 beers,
16?
that's what I recall from my review of this. So that's not a beginner.
That is not a beginner, no. But it certainly is an individual who is perhaps struggling because of the emotional strain of a relationship that really matters to him that is going right down the toilet, and maybe rightfully so. But at 19, are we really asking a 19-year-old to have the life experiences of an adult, a 25-year-old, a 30-year-old? He's accepted responsibility for what he's done. He can't take it back. He would like to, because as he indicates to me, he has lost somebody that he really believed he might have been with for the rest of his life. He also recognizes not only is he accepting responsibility for hurting Carly, but he recognizes that entering a plea on a felony 4, it's a violent felony offense. It's going to be on his record forever, and that's a consequence he must pay. Judge Probation mentions anger management, and quite frankly, that would probably do him some good. Quite frankly, a drug and alcohol assessment and treatment obviously would do him some good. But at 19, can't we help teach this young man that the conduct that he engaged in, even though he maybe had a momentary lapse of emotional dysregulation that kind of, resolved.
It's hard to describe beating a woman, strangling a woman, abusing a woman, a young 19 or 18-year-old woman.
It is tough, Judge.
Yeah, it's a tough job.
But he has never committed an act like that before. He's got a very low aura score, which indicates he's not likely to reoffend in the future. And by all accounts, he does have a bright future, and I know that he wants Carly to hear from him how sorry he is. She's not here, and nevertheless, he'll address the court here in a moment. But to that regard, I disagree that incarceration, the message has been sent to this young man. It really has changed his life already. I would ask the court to consider a probationary term, require him anger management, require him alcohol treatment, maybe a full mental health assessment and appropriate treatment, maybe batter's intervention. But jail is a consequence that as a first offender on a felony 4, where he's accepting responsibility, it may be too much in this instance, Judge. So we'd ask the court to consider probation as an alternative.
Well, prison would be too much, generally, for a first offense with someone who fully complies. 180 days in jail wouldn't be out of the question. I notice your mom and dad have what you describe as a good, healthy relationship.
Yes, Your Honor.
So this obviously was not modeled for you. I'm trying to figure out where this comes from. But go ahead, it's your turn now.
Can I blow my nose?
Yes, sir.
Thank you. Your Honor, I just want to accept responsibility for everything. I'm not here to negotiate or argue with you about this incident, but your question is to where you think this came from, and in my eyes, as Mr. Peeler or Mr. Perry has described to you, that this was my first relationship I've ever been in. I truly think, in my eyes, I did love her. I know love is a strong word to say, and people think they love someone and they don't, but I truthfully think I did. And when times got hard between me and her, and we were going through our break and everything like that, I kind of went off the edge a little bit, and I, like you said, I consumed alcohol. I don't know where you've seen I consumed 16 beers, if I said that.
I'll go back and review this, but I'm almost sure I read that.
It's reported in his Talbot House assessment.
Okay,
That's what I told her.
okay. Generally, if you tell somebody something, people understate it. So go ahead. If you disagree with that number,
No, I don't disagree. If that's what I said, that's what I
Okay.
said. But at the same time, with that number of beers and me not being a drinker, like Mr. Perry said, the last reckless stop I had, that had nothing to do with drinking or anything. That was a speeding issue.
How fast were you going?
I can't remember to be.
Try to tell a judge whatever you can.
Well, I was just coming out of town and I accelerated extremely hard. So
Okay, well, you've paid for that already. I was just curious.
yes,
Go ahead.
but with the amount of alcohol I had consumed, with me not having an issue with that, I think that's why things happened the way they did. And since that day on, I've not drank any alcohol. I've passed every single drug test that I think I've done, like 10 now. So
Where's the behavior come from?
that's where I think the behavior came from me drinking too much alcohol at that time, and I understand that, and I wasn't myself, and it tore me apart, and I've learned from my responsibility, and I've changed since then, and I never want to be in here again. That's not the person I am, and I've accepted responsibility.
Okay.
Judge, may I interject real quick? I meant to ask the court to order a no contact order as a condition of any probationary term with the victim, Carrie Craiglin. I forgot to ask for that.
Okay, fine. Okay, so everybody had their chance.
Judge, just to be sure, we submitted several letters for the court's review a couple of days ago. I think those letters speak very well of who Gabe is. Generally speaking, again, this night was a terrible night, but it was an anomaly. It's not what he's never done it before. He's never been charged with that before. He can absolutely learn from this incident in the right ways, so it never happens again.
Okay. You know, I don't have all the words that probably fit this situation totally. I can say that, yeah, you've got this on your record. You can overcome that. You're young. It's an unforgivable act, what you did. And it makes sense that you'll never see her again, really. Why would she want to see you again? I don't know. But there are other people out there other than one person, and maybe she'll find someone who treats her better, and you'll find someone who is happy that you changed. So that's one part of it. You never know what you're going to run into. I have 2 daughters, and I was, you know, if I put myself in a situation, which I never would, where I had to decide something knowing somebody did this to them, it wouldn't be pretty for you. And you may feel the same way someday when you have a daughter. But you're young, you don't have a history here. You may have this on your record, but your future is spotless. And you, in my opinion, you need to just basically give up alcohol. That may sound like a lot for a 19-year-old, but you two don't seem to mix very well.
No, Your Honor, and like I said, I have since that time, and I plan on continuing that.
That'd be one of the smartest moves you ever make in your life if you do that. And I hope you do. You're going to be ordered to refrain from use of alcohol while you're on supervision. I find that he is amenable to community control. Place him on community control for a period of 3 years. Order him to complete corrective thinking. Order him have no contact with the victim in this case during the term of supervision. Order him to complete anger management. You've already have your GED?
Yes.
Okay. To maintain your employment, sounds like that's not a problem. To do 40 hours of community service at a women's shelter, if they'll allow him to be there, or a homeless shelter, such as the Hope House, where you'll get to see a different side of life than what you've been raised in. If you leave the state of Ohio without permission of the court or your probation officer, if you commit a violation of any law, or if you just don't complete the rules that I've given you here, the court may impose a longer time under the same sanction, may impose a more restrictive sanction, or may impose a prison term. The range from which the prison term may be imposed as a sanction for this violation is 6 to 18 months. Is it 6 to 18 months?
Yes, sir.
6 to 18 months. Do you have any questions?
No, Your Honor.
You have a right to appeal this sentence.
Judge, I'm sorry, I mean, there's a couple things that we need to add in this. There's a mandatory $565 fine because of the OVI.
Oh, I forgot about the OVI. This is, okay, $565 fine and a 1-year license suspension. Did you figure out the
Judge,
effective
I
date?
cannot find any documentation that
Okay,
he
well-
was placed on ALS, so the effective date would be today.
We'll make it effective today. However, if it turns out his license was suspended, you can bring it back and we'll
I will.
modify that.
Right.
Thank you, Judge.
You're-
He gets privileges to drive after, is it 18 days now?
Judge, I think the court previously granted him limited driving privileges.
I don't know, he couldn't have been suspended.
I got on,
Hold on.
Well, the only, and Judge, I totally agree. The only issue is, as the court's aware, normally in the record, and I've looked through the record from the lower court, normally in the record, there is, number one, a 2255 form, which is where he's officially notified, and then there's an ALS suspension form, which is placed of record if he's suspended. Neither one of those documents exist in the record, but certainly if they turn up, then I don't have any problem with that. The additional thing, judges, would be court costs.
Okay, impose the fine.
Yes, sir.
The minimum mandatory fine for the OVI, impose the court cost.
Okay.
I'll suspend his license for 1 year. By law, I cannot give him occupational privileges for the last I heard it was 18 days.
It was a refusal, so it'd be 30.
Okay, for first 30 days. Other than appellate rights, is there anything else I need to address, Mr. Goodyear?
No, sir.
Mr. Perry?
No, sir, Judge.
Okay, sir, you'll have to find somebody to drive for you for 30 days unless they suspended your license, and we just don't have the record of it here today. If they did, Mr. Perry could come back. I can backdate this to the date of the offense. You have a right to appeal this sentence. You have 30 days from today to file a notice of appeal. If you cannot afford an attorney will be appointed to represent you. Any document would be provided at no cost. Do you have any questions?
no, sir.
Okay, good luck to you.
Thank you, Judge.
Thank you, Your Honor.